Good evening. In UK and also in Bulgaria, my name is Aurélien Lorange. Together with my colleague Miss Urbanova, we'll be having this day 3 match between two teams. I give the floor to my colleague.
Thank you very much, and indeed, good evening to everyone, and also good day to those of you who might be joining us from where you don't have evening yet. It is a pleasure to welcome you to the round 3 debate for the University of Birmingham and Sofia University debating teams. The topic of today's match lines up with the theme of the third round, which is cybersecurity and blind technology. Specifically, the teams will be debating on the topic whether, in light of growth in cross-border teleworking, countries should prioritize the establishment of well-defined digital boundaries to regulate and govern online activities effectively. So the teams had 7 days to prepare. They've prepared as usual for the two sides of the argument. And before we find out which team will represent which side, it is time to learn a bit more about our debaters today. So perhaps starting with the University of Birmingham's debate team, Miss Sedani, the floor is yours.
Hi, my name's Krisha and I'm a final year law student at the University of Birmingham.
Thank you and welcome. For joining us from Sofia University, Ms. Angelova.
Hello everyone, my name is Maya. I'm in my second year of law school and I'll be representing Sofia University in this debate and I'm really looking forward to it.
Thank you and welcome. From University of Birmingham, Mr. Raj.
Hi, my name is Ranveer and I am a final year law student at the University of Birmingham.
Thank you and welcome. Joining us from Sofia University, Ms. Mkrtchyan.
Hi everyone, I'm Teresa. I'm my first year of law degree and I represent Sofia University.
Thank you and welcome. From University of Birmingham, completing your 3-member team, Mr. Mohar.
Hi, I'm Sarish. I'm final year law student from UOB.
Thank you and welcome. So the teams also have support, of course. Sofia University also has one of their coaches present on today's call, Mr. Kuchikov. The team is also coached by Ms. Donskaya. And on that note, passing the floor to Mr. Kuchikov.
Hello everyone, my name is Martin and I'm in my 4th year of international relations degree at Sofia University. Last year I was a competitor, this year I'm a coach and I'm completely thrilled to be a part of this competition once again this year and I'm looking forward to this great opportunity. Thank you.
Thank you very much. And also from the organizing side, thank you everyone for preparing and best of luck for the debate ahead. So without further ado, if I can just ask for confirmation that you can see the screen.
Yes.
Thank you. Thank you very much. So as always, we have 4 possibilities for the allocation of positions. All right, so for today's debate, it will be University of Birmingham's debate team that will argue in the position against of the statement to confirm the argument in favor and thus arguing that in light of growth in cross-border teleworking, countries should prioritize the establishment of well-defined digital boundaries to regulate and govern online activities effectively, will be argued by the debate team of Sofia University, who will also start with their opening statement. The position against will be defended by University of Birmingham. You now have 5 minutes to finalize your preparations. Feel free to close your cameras. Thank you very much. The final time for preparation is now over. We'll be starting with the team in favor. So for the opening statement, you have 4 minutes, whenever you're ready.
Okay, I would first like to ask if I'm audible and visible.
Yes, you are.
Okay, thank you. Good afternoon to the fellow judges and to my colleagues from Birmingham University. On behalf of myself and my teammate Teresa, we're very pleased to discuss this topic with you. Today we'll be arguing that in light of growth in cross-border teleworking, countries should prioritize the establishment of well-defined digital boundaries to regulate and govern online activities effectively. We'll present three main arguments. Firstly, we'll argue that the lack of regulations creates ways for tax evasion. Secondly, the implementation of regulations would lead to safer working space and security for teleworkers. Lastly, we'll argue that those regulations are beneficial for both the employees and the employers. We rely on the definition of teleworking provided by the International Labour Organization. Namely, it's a form of working that's performed at a distance with the help of technology. According to recent statistical data provided by the Eurofond research, the recourse to teleworking by individuals has strongly increased since 2020. Evidently, one of the main reasons for that was the COVID-19 pandemic. I will now focus on our first argument. The lack of regulation creates opportunities for tax evasion. It is well known that taxes are the primary source of revenue for most governments. Thus, taxation is of great importance for them. At the same time, globalization has been increasing and many teleworking opportunities have appeared. Those factors make it harder for states to maintain taxation. According to a report by the Organization for Economic Cooperation and Development, people who work remotely in foreign countries might be inclined to avoid paying taxes. For such purposes, they tend to hide their assets or even register them in third states that are tax-free. For example, the United States of America has registered growth in the cases of tax fraud, basing their reasoning precisely on the increased assets registered in tax-free countries. That's the reason why governments should create digital boundaries to prevent such cases. A relevant case law in that respect is the Mulox IBC Limited versus Henry Gilles, which was addressed by the European Court of Justice. In that case, a French employee had obtained an agreement to work partly in Britain before taking up residence in France, whereas he was allowed to telework and travel to London only once a week. Consequently, there was a dispute over which country should the employer pay taxes to. According to the court, it had not been agreed where the employee would work permanently. This lack of agreement or legislation created a clash of laws. We argue that such issues can be avoided by creating a relevant regulation in the field of teleworking. Thank you.
Thank you very much. We'll now hear the opening statement in the against position. You have 4 minutes.
Can I check if I'm audible and also visible?
Yes, you are.
My speech will start in the next 5 seconds. Sorry, something was wrong with my screen. Just double checking. I am visible, right?
Yes, you are.
There are two important points of context and framing. The first is that this is not a motion about a general notion of regulating teleworking, but rather it is a motion that is specific to teleworking in cross-border situations. The second important point of context is that this is also not a debate about whether regulations in and of itself is a prima facie good or not. This debate is about whether the agent that is deciding and enforcing these regulations ought to be the state. So our case from Birmingham is simple. We're not saying that there should be no regulation. We're saying that the actor in this question, aka the state, is the wrong arbiter at making that assessment. Birmingham will forward three arguments in contention. The first is that increased regulation violates the principle of regional and economic cooperation that is envisaged by international law. Second, that countries are misplaced to regulate cross-border cases, and in doing so is an overreach by states which achieve no real resolution. The final argument we'll bring is that increased regulation curtails autonomy of employees rather than promote it. The first point of contention here is that the idea of prioritizing the regulation of teleworking would be detrimental and extremely contrary to the very principle of regional and economic cooperation that is envisaged by international law. This is boosted by the bedrock principle of regional economic cooperation, which forms the basis of the European Union. This is pointed out in GETS Article 1.2, Mode 1, that promotes a liberalization of trade in services, including teleworking, and therefore indulging in excessive regulation would necessarily contradict these provisions. My second argument is why this will result in a conflict of law that would cause this situation to be even worse. There are points of rebuttal I want to make to the previous speaker. The previous speaker suggested that the way in which we can solve these conflicts of law are by national regulations. But actually, it is national regulations themselves that are the source of this conflict. The reason for this is because the argument on having regulations is not an end goal, but an instrument to facilitate better lives and protections for people, to the end at which they achieve no solvency. In other words, they cannot prove that people are better protected under these regulations, then that regulation achieves absolutely no purpose. The thesis of this argument is simple, that the basic principle of the conflicting rules in the state of employment principle, known as the lex loci laboris, means that an employee is often subject to the social security legislation of that member state in and of itself. The problem with the argument by the previous speaker is they believe that that example of that French individual who commutes to London every other week is an argument for their side, is something that is baffling. The reason why is because in that particular case, the court stressed that an employee will be well advised to clarify the employment relationship and expressly indicate the employee's usual place of work to avoid the application of unwanted law. That is to say, the courts have said that national regulations should not be fighting among themselves to claim territory, like to claim that the place of work is in their territory. Rather, that case said that there is a difference when countries try to fight among themselves to claim that territory vis-a-vis the fact that this is something that the contractual terms in and of itself should provide. What is important, therefore, is that they determined in that particular case that the contract was to be governed by British law. However, in the secondary case, by Rutten, the case of Rutten says was the similar case where a French employee of a British company was teleworking from Paris. And in that case, the Supreme Court said that the contract was subject to French law and not British law because it is one that the contract should be hold primary interest to. So it should be about the contract rather than whether national regulations themselves promote this framework. For all these reasons, we oppose.
Thank you. We have now heard opening statements for both positions. We are now entering rebuttals. So, Sofia University, you have 2 minutes for your first rebuttal.
Am I audible and visible?
Yes, you are.
Okay. Turning to our second argument, stricter regulation on teleworking will ensure safer working space and security for the teleworkers. When providing work for foreign companies, the lack of any digital boundaries may lead to violation of the rights of teleworkers. For example, under the Article 7 of International Covenant on Economic, Social and Cultural Rights, workers have the right to enjoyment of just and favorable conditions of work. And as a pair of commentary of the Covenant, security is one of the elements of the rights provided under this provision. Privacy is a key factor when speaking of security in digital space. And since personal information can often be easily accessible, for example, selling it can pose risk to the worker's privacy. It is of the great importance to regulate all of the employer activity when using technology. An example of how lack of well-defined borders affected the protection of privacy is the 2021 Facebook issue. In this situation, when someone had managed to steal the information of 500 million users, the stolen data include personal information such as full names, birth dates, phone numbers, and email addresses. The hackers then posted the data online for people to see and use for free. The establishing strict rules will enable people to protect their personal data and internets regardless of their location. The only cause to show that if appropriate boundaries aren't taken, the harm can be at a great scale.
Thank you very much. Now for the 2 minutes in the against position, University of Birmingham, whenever you're ready.
Hi, can I please check that I'm audible and visible?
Yes, you are.
Sorry, my volume is off. Sorry, could you just repeat that?
Yes, you are visible and audible.
Thank you. Thank you. So I would like to address the main argument that was given by my colleagues in University of Sofia. The main argument was that we need regulations in order to conduct a safe environment and not sell things such as personal data. However, I would like to remind them that the motion is that we should increase and prioritize these regulations. The regulations to create a safe environment are already there. You are already not allowed to sell personal data. Take the GDPR regulations. Personal data must be kept only for extreme uses, and you cannot go about just selling them. Therefore, the motion is about increasing these regulations, which we argue would only infringe on individuals' autonomy rather than making a safer environment. For example, states sometimes lose sight of what an employer's goals are, and they do not work in the employer's favor. Take the Foreign Account of Tax Compliance Act, enacted by the United States Congress in 2010. This act requires foreign financial institutions to report information about financial accounts held by US taxpayers to the Inland Revenue Service. This increases costs for these companies and means that the higher cost of compliance restricts market access, puts them at a competitive disadvantage, and also increases puts them at a competitive disadvantage, and therefore infringes on their autonomy. Therefore, as going back to the point made by Suresh, the states are not in the position to be doing this, and we should therefore leave it in the hands of the corporation and leave it in the contracts between the employer and the employee.
Thank you very much. So we will now hear the second rebuttal, starting with Sofia University. You have 2 minutes.
I would like to ask again if I'm audible and visible.
Yes, you are.
Okay, thank you. In response to the argument of the opposition regarding the clash of national regulations, we would like to point out that this scenario is unlikely. Dear judges, please note that almost all of the new legislations on teleworking worldwide have very similar provisions and are not contradictory to one another. For instance, the new laws in Angola, Argentina, Australia, and Belgium on remote working all implement principles as a requirement for written agreement and protection of the rights to disconnect, as well as special protection and priority to the right to telework for the more vulnerable groups like pregnant women, people with disabilities, and the elderly. I will now focus on our last argument. Stricter regulations lead to beneficial consequences for both the employers and the employers. By prioritizing establishment of well-defined digital boundaries, states will create national legislation with appropriate mechanisms in order to protect the digital rights of workers. Since teleworkers do not have a certain time frame of working hours prescribed by legislation, this can erase the distinction between work and private life. The legal term for this condition is disconnection. For that reason, Belgium has adopted the so-called Act regarding the strengthening of economic growth and social cohesion. It concerns precisely disconnection and the use of digital communications. Articles 15 to 17 establish a special organ, namely the Prevention and Protection Committee, which deals with the issue regarding regulation and help for workers who struggle with disconnection. This only goes to show that having the appropriate measures on a national level can significantly develop the telework process while protecting fundamental human rights and providing a better environment for foreign workers. Thank you.
Thank you very much. Now to hear the second rebuttal in the against position, University of Birmingham, you have 2 minutes.
I just want to confirm whether I'm audible and visible.
Yes, you are, but there is an echo, so if you can...
Yep, certainly.
Yes, now it's better. Whenever
Thank
you're
you.
ready.
Sure. Good evening, distinguished judges and my fellow colleagues and participants. Now the case is very simple. I would address 3 points within the points mentioned by University of Sofia. The primary point being that excessive regulation is not necessarily beneficial for employers. And the reason for that is excessive regulation would unfairly target the MNCs, which recruit skilled individuals from a wide variety of countries. By providing excessive regulation, we would be infringing on the autonomy of these private entities. The matters of cross-border teleworking are best decided by private international law. State actors don't have a place in order to interfere in the private actions or the private contracts which govern such relationships. A company, for example, in India and a company in US would be governed by the employment contract within that framework, not necessarily the legislations. Building on to my second point, what my learned colleague from the University of Sofia stated, there would be conflict between national laws. And it's very simple. The reason is very simple. How we define things, how we define a worker, how we define an employer is different for different nations. And that would result in further discouragement or a further issue which would rise while deciding employment disputes. The third point that I want to emphasize is that of data protection, which my learned colleagues from University of Sofia stated. Now, excessive regulation is not the solution, as my colleagues Ms. Sedani and Mr. Mohar have been stating. The case of Schrems, decided by the Court of Justice of the European Union, is a crucial example of that. Within that case, the Court of Justice invalidated the European Union and United States Private Shield Pact, which provided for regulation of privacy of private data. Now, it is important to point out that even the court's approach is indicative of the fact that excessive regulation is not the solution at the end. It is important to understand these matters are between private entities and hence are better to be dealt by the private entities themselves.
Thank you very much. We will now proceed to the conclusions. For the position in favor, Sofia University debate team, you have 2 minutes.
I would ask, am I audible and visible?
Yes, you are.
Okay. I would firstly like to thank opposing side for their statement. Throughout the course of this debate, we have demonstrated that countries should prioritize the establishment of well-defined digital boundaries to regulate and govern cross-border teleworking effectively. Dear judges, we firstly addressed the opportunity for tax evasion without stricter regulation in the case of Mulux v. Hendrik Kiels. Having stricter regulation from countries on cross-border teleworking could help reduce case of tax evasion, for example, by implementing measures that enhance transparency and enforce compliance. Secondly, we point out that those regulations will ensure safer working space and the security of the employees. Almost all of the new legislation on teleworking worldwide concentrate on protecting the essential right of the teleworkers, like the right to the employment of just and favorable condition of work. We relied on the 2021 Facebook issue to show how important digital boundaries are, especially with activities like teleworking, which require processing data. Lastly, stricter regulation from countries on cross-border teleworking has many beneficial consequences. The Belgium argued regarding the strengthening of economic growth and social cohesion from 2018, and the figures it established and expansion for how this regulation facilitate the teleworking process. We have clearly demonstrated through our argument that the establishment of well-defined digital boundaries by the countries is important for the future development and facilitation of teleworking, as well as for protecting the internet of teleworkers. Thank you.
Thank you very much. We'll now hear the conclusion of the against position. University of Birmingham, you have 2 minutes.
Am I visible and audible?
Yes, you are.
I'm just going to ask two simple questions in this debate. The first is, can the laws actually be enforced? And secondly, how do courts make decisions currently? Because to be very honest, this is a very difficult motion for opposition, and I think everyone will probably think that. But the problem is that proposition has to do just one thing. They have to tell us why states are the best placed actors at regulating these online activities. This is not a debate about having regulations full stop. This is about whether states are the best agents at being able to carry out these regulations. That's why most of the argument coming from the proposition team was about why we need regulations, which is a moot point. Rather, they need to tie in why the importance of regulation should be funneled and guarded by states rather than corporations. That's a distinction that they don't actually prove. If they do not prove this, then they can't win this debate, because even if we agree regulations are important, we need to know why regulations should be guarded by the state and not the companies. This is an important point of distinction. So therefore, I want to move into my very first question, which is, can you actually settle the conflicts of laws? Both sides agree that the laws are going to come into conflict with one another, as pointed out by the very first speaker. But the third speaker then retracted this by saying, no. Even countries like Angola and the EU will agree on base principles. They might agree on base principles, but they will disagree about some other things. That's why the own case brought up by the first proposition speaker about the French person living in London and commuting once a week results in that conflict situation, because the French government wants to claim that workplace as their territory, while the English people who want to claim everything also claim that to be their territory. So in cases like this, how did the courts then resolve this issue? The courts actually said it is not a matter for independent countries to claim that territory. Rather, it's a matter for the employment contract to specify where that domain or where those business activities are to be carried out. Therefore, even in that situation, courts have said it's about the contract rather than national regulations. If courts are deciding it in that way, who are we to say that we need more regulations? We oppose.
Thank you very much. This marks the end of debate. You can relax. You will no longer be graded after this part. On the side of organizing team, I would wish to just say congratulations and well done for completing your round 3, for preparing and for presenting your arguments. It must have been quite a difficult journey. So before we go to the conclusion of the session, I would just like to pass some questions on the feedback of the debate. Perhaps starting with the University of Birmingham's debate team, perhaps Mr. Raj, how did you find the debate? What did you perhaps already encounter this topic or aspects of this topic in your studies?
The debate was quite interesting, and I believe the area of cyber law is something that is pretty important in light of recent developments within the European Union and in general in the international legal frameworks as well. We see the Artificial Intelligence Act coming up, we see newer legislations coming up. I think as a topic, I got to learn more about cyber law, which is not really a conventional module in a majority of law degrees. And more than that, I believe the case for opposition while we were preparing, and I think my colleagues would agree, was really interesting because it puts us in a unique position of opposing regulations, which is the bedrock of parliamentarianism and law. So that's quite interesting how to develop or devise that approach in order to ensure that the private parties preserve their autonomy. So I really enjoyed the topic. I think it was a unique approach. That the opposition case was definitely a unique approach from what I've usually seen.
Thank you. Thank you for sharing. It's good to hear that it was a challenge and that how you approached it. For Sofia University, Ms. Angelova, how did you find the debate? Did you perhaps already encounter aspects of this topic or the whole topic itself in your studies?
Actually, no, I haven't. I'm still in my second year of law school, so I'm not into quite this topic yet, but it was very interesting and for sure challenging, as the Birmingham team said. And it was challenging, especially in finding international and case law. But yeah, I think it was a quite experience and was very good overall.
Thank you. Thank you very much for sharing as well. Passing the floor back to University of Birmingham, Ms. Sadani, how did you find the topic? Perhaps, did you hear arguments from the other side that your team also prepared?
Sorry, could you just repeat that?
How did you find the debate? And perhaps did you hear arguments from the opposing party, which your team also prepared, if you were given this position?
Yeah, so I really enjoyed it. As I think everyone else stated, I haven't learned this area of law before. So it's really interesting learning about something that I didn't know and also linking it back to what I already did know, for example, about GDPR and EU law. And the other side, yeah, we did have some similarities, which was good because it meant that I could prepare for it. For example, things such as how it's beneficial for employees and employers and it creates a safer environment. So that was nice to see. But there were also some arguments that we hadn't thought of. For example, taxation, we didn't delve into the argument too much. But it's interesting to see how our minds were working and formulating the arguments.
Thank you. Thank you for sharing. Same question for Sofia University. Ms. McChan, how did you find the debate? And perhaps did you hear the arguments from the other side, which your team also encountered in your preparation?
The first, I want to thank for this opportunity. We really enjoyed this game. Yes, we prepared very well, and we are ready to play for both position. So yeah.
Thank you. Thank you for sharing. For University of Birmingham, Mr. Mohar, how did you find the debate?
Hi. Yeah. So I think it was a very interesting topic because I think a lot of people like cyber law and like tech stuff, but I'm not really a tech geek or like into these sort of stuff. So it's a bit like, so every area is pretty new for me in terms of being able to research and then being able to try to make it concise enough for the 4 minutes. I think was a struggle. And yeah, so I think the process researching this motion has been quite enlightening. It is something I would not come across if not for this tournament.
Thank you. Thank you for sharing. And it also gets switched to the final part, which is a little bit of networking. And also, as you have now completed your round 3 debate, you have also completed your participation in the group phase. What awaits you next is of course, the compilation of all the scores for all the teams that participated in round 3. And then final evaluation, who will then proceed to the next phase of the competition, which will proceed in April after the Easter break. Before we proceed to the next rounds, of course, there is a ceremony in a mid-edition event, if you will, where we will also announce the matchups for the 8 finals. And also there will be a hosting of a networking event for all the students. So you will be able to meet the students from your previous matches, but also students from the groups that you were not matched with. And on that note, my question would be, how did you find the group phase? One team already has a certain experience about the competition from the years prior. For another team, it was the first time participation. So perhaps giving the floor to University of Birmingham, how did you find the experience? Did you perhaps see, as we always see on the side of organization, and your team is also the case, perhaps what skills did you improve in particular that you could think of right now?
If I may go first, what I believe is that the format is pretty unique from conventional debates, especially the nature of deciding the proposition or the opposition side. So I think that gives us a room of adaptability, which is absolutely a crucial skill for anybody in the legal profession, because you never know, you might get a case one day before and then you have to proceed. And I believe that's something that we learned over the period of 3 debates as well. And we further analyze both situations. So I believe that one of the unique things was that analyzing both the situation really helps with the rebuttals. And it's really interesting to see that it can be conducted in such a unique format.
Thank you for sharing. If anyone else also from your team would like to give their opinion. All right. On that note, I'm passing the floor to Sofia University. How did you find the group phase? Is there anything in particular that stood out to you as well during the participation?
Personally, for me, I found the group phase very interesting, and I think that it really helped me learn how to do research, especially because I still haven't learned international law, and so it was interesting to see all of the case laws from the different jurisdictions and so on. So yeah, I think the research part was the thing that really made a big difference for me, and also maybe the teamwork part, because in this debate, I think it's very important to have really great teamwork.
Thank you for sharing. So as well, group question, whichever of the students also wishes to answer, perhaps Mr. Dani, Mr. Mohar, or Ms. Martachan. Is there anything in particular that stood out to you during the group phase? Perhaps even if you had the chance to watch other matches outside of your group, if that was an inspiration, perhaps.
I think it was really interesting because this was our first time in this debate. And I really enjoyed the fact that we had a practice debate beforehand. That's something that stood out for me. And I've also never had a debate online either. So that was really interesting and something new that I hadn't done before. But I really enjoyed the support that we were given with the practice debate as well, the feedback that we were given as well. And overall, I really enjoyed the group phase.
Thank you for sharing. Right. Speaking of online debates, the final debate, which is of course open to all the participants, no matter their part in the competition, will be held in The Hague on the 19th of June. If you will be traveling, if you have the option to travel, we have a partnership with KLM and Air France to help you get the tickets perhaps at a discounted option. So don't hesitate to let us know. And similarly, in about a week or so, you will have received the information in regards to mid-edition ceremony and the networking dates and times. We'll try to accommodate as much as possible, but at the moment there are 14 time zones for the participants in the competition. So we'll try to find a time which is not too late or too early for anyone. All right. Well, on that note, I wish to congratulate you once more. Thank you for preparation and have a good rest of the day.
Thank you. Thank you very much.
Thank you.
Bye-bye.
Thank you.
Thank you.
Thank you. Bye.